Hey everyone, and welcome to this explainer. Look, if you're the kind of person who loves knowing how things actually work under the hood, you are in the exact right place. Today we're focusing all our attention on one absolutely foundational concept in business law, the contract of sale. We're going to look specifically at how this is defined under the Sale of Goods Act 1930. And hey, I know legal text can sometimes feel a bit, well, dense, but don't worry. I'm going to break this down so it's as simple and easy to understand as learning your ABCs. We are strictly focusing on the legal machinery behind buying and selling today. So get comfortable and let's get started.
Okay, let's dive right into this. We buy stuff literally every single day, right? You might have bought a cup of coffee this morning, or maybe you recently treated yourself to a new smartphone. But what exactly makes those transactions legal? What actually separates a casual exchange between friends from a legally binding sale that a court would step in and enforce? It's not just about handing over some cash. There's this very specific, invisible legal framework working in the background. To really grasp this, we need to look at the exact legal definition of what we're doing.
All right, so here's the cornerstone of it all. According to Section 4, Subsection 1 of the Sale of Goods Act, 1930, a contract of sale is a contract whereby the seller transfers or agrees to transfer the property and goods to the buyer for decided price. Now, the absolutely crucial word in that sentence is property. In everyday life, when we say property, we usually mean real estate, like a house or a piece of land. But in this specific legal context, property under Section 211 actually means absolute ownership in the goods. It doesn't just mean you're holding on to it for a bit, which the law actually calls a special property. It means you are the absolute ultimate owner of it. So a contract of sale is basically the legal mechanism for transferring absolute ownership from one person to another.
Now think of this kind of like baking a cake. A valid contract of sale needs specific ingredients. If you forget even one of them, the whole thing completely falls flat legally. Let's walk through these 5 essential ingredients step by step. First up, you need at least 2 distinct parties, a buyer and a seller. You obviously can't legally sell something to yourself. Second, there has to be an actual agreement of sale made between those parties. Third, the subject matter of the contract has to be goods. And here, goods means any kind of movable property, like a car or even a standing crop of wheat out in a field, but it specifically excludes actual money and actionable claims. Fourth, there must be a transfer of the subject matter, meaning that absolute ownership we just talked about has to actually move from the seller to the buyer. And fifth, there must be a lawful consideration for the contract, which for a sale is known as the price. Price is explicitly defined in the Act as the money consideration for a sale of goods.
I really want to zoom in on that 5th ingredient for a second, because it brings us to a fundamental rule. No consideration, no contract. This is an absolute bedrock principle. In a contract of sale, the consideration has to be money. It has to be a price. If you're just trading, say, a bicycle for a skateboard, that's a barter system, not a contract of sale under this specific act. If you're just giving a car to your friend for free, well, that's a gift, not a sale. For a valid contract of sale to actually exist under this law, there has to be a lawful money consideration. Without that price being paid or promised, the entire contract basically just doesn't exist in the eyes of the law. Now, what's really interesting about this is contract of sale is actually a generic umbrella term. It's a broad category that covers 2 very different legal situations, and it all depends on exactly when the ownership transfers. Under this umbrella, we have a sale, which deals with the immediate transfer of ownership, and an agreement to sell, which deals with a transfer that's going to happen sometime in the future. Let's look at exactly how to spot the difference between these two.
Scenario 1 is your standard everyday sale. A sale happens if the property and the goods, again, that absolute ownership, is immediately transferred from the seller to the buyer. A perfect real-world example is paying cash at a showroom and driving away with a new car. You hand over the price, they hand you the car, and the title and ownership transfer right then and there on the spot. Boom, the transaction is totally done. But now, let's contrast that with the second scenario, an agreement to sell. This happens if the property and the goods is agreed to be transferred at a future date, usually after certain conditions are satisfied. So let's go back to that car dealership. Imagine you go in, but this time you're ordering a brand new, customized car that hasn't even been built yet. It's going to be manufactured and delivered in, say, 3 months. You sign the paperwork today, sure, but you are not the owner today. The transfer of title is only going to happen in the future, once the car is built and the final conditions are met. That right there is an agreement to sell.
To really cement this and keep things super beginner-friendly, take a look at this breakdown. It visually maps out the stark contrasts between these 2 variations. We've already established the basic difference in timing, immediate versus future. But the legal consequences of that timing, they are massive.
So let's break down the specific legal terms and the real-world consequences over these next couple of slides.
First, let's look at the nature of the contract and the rights it creates. In a sale, the nature of the contract is executed. Now, that's just fancy legal jargon for a done deal. Both the buyer and the seller have completely fulfilled their contractual obligations. And because it's a done deal, it creates what's called a right in rem. This means your right of ownership is valid against the whole world. If you bought that car and drove it off the lot, literally nobody else in the world can claim it. On the flip side, an agreement to sell is an executory contract. That just means the contractual obligations are still pending. The parties still have things they need to do. Because it's really just a promise for the future, it only creates a right in persona. This means your right is only against an individual, specifically the seller. You have a personal right against the dealership to fulfill their end of the contract, but you don't actually own the car against the rest of the world yet.
And this brilliantly illustrates why any of this actually matters. It all comes down to who takes the hit when things go wrong. Look at the risk of loss row here. There's this general legal rule called risk parent domino, which translates to risk follows ownership. Basically, the legal owner bears the loss, regardless of who is actually holding the item. So, in an executed sale, the risk of loss falls entirely on the buyer because they are the owner immediately. But in an agreement to sell, the risk remains with the seller because the ownership hasn't transferred over yet. Also, think about what happens if the buyer breaches the contract. In a sale, the seller can sue them specifically for the agreed price. But in an agreement to sell, the seller can only sue the buyer for damages, not for the actual full price, because the final sale hasn't happened yet. Finally, because ownership has fully transferred in a sale, the seller absolutely cannot resell those goods to someone else. But in an agreement to sell, since the seller still technically owns the goods, they could theoretically resell them, though of course, they'd definitely be on the hook to pay you damages for breaking your agreement.
So, there we go. We've systematically broken down the contract of sale into its absolute basics. We've defined it, we've identified the 5 vital ingredients, like the absolute necessity of a monetary price, and we've explored the massive legal divide between an immediate sale and a future agreement to sell. Now, I want to leave you with a question to really test your new legal lens. Think about your last major purchase. Did the absolute ownership and the risk transfer to you the very moment you handed over the money, making it a fully executed sale? Or were there conditions to be met in the future, leaving the risk sitting with the merchant as an agreement to sell? Try applying this framework the next time you buy something, and I guarantee you'll see the legal mechanics working right before your eyes. Thanks so much for joining me for this explainer, and keep learning.